So it is good. You have to inherit provision, copy the provision from US, because US does it, Germany does it, all developed countries does it, India should also do it. And therefore we say our legislation is forward looking legislation. I think legislation should always be such that it will be keeping in mind the local aspects, Indian aspects or the country specific aspects. Here the difficulty is getting you a person. Now here another point I would like to make, not that enough females are not available to be appointed as, there could be, but still many of them are not mentally prepared to take up that position. So is there a proper mentoring program which is being undertaken? Why it has not been made mandatory? But as such, government is as of now insensitive. And in that line, I have borrowed some piece of information whereby even Singapore is ranked 7 in Asia Pacific region. We consider Singapore to be a better country, business friendly country, outspoken kind of a society and all that, but still Singapore is 7th in Asia Pacific, forget about US and Europe. So India still lags. It has voluntarily called for violation of law. Many companies, so they have asked for, sir, how do we comply with? Again, our typical creativeness comes to the fore. I've said, okay, you give an advertisement in 2 newspapers, keep a cutting and say I have made reasonable efforts but I could not get and therefore I could not comply. MCA will have to take a lighter view of this non-compliance, SEBI will have to take a lighter view of this non-compliance. But unfortunately, they have just bluntly pushed through that there has to be a one-woman director. Cooling period is only 1 year. I have my own reservations on this. Independent director, I think it is widely discussed. All of us are aware, in a listed company, 1/3 of the total strength of the board. In the public companies where paid up share capital is 10 crore or more, 10 crore of 100 crores, they are all, cooling period is 1 year. Again, I believe independent director definition could be taken in detail. In case of a vacancy, fill up the earliest but not later than immediate next board meeting or 3 months from the date of such vacancy. That has to be taken into account. Because why I have covered this particular point, if you are keeping update with corporate movements, there have been exodus in certain companies wherein en masse 2, 3, 4 directors have resigned. And when 2, 3, 4 directors have resigned, maybe because the auditor wanted to disqualify the auditor report and therefore the audit directors were not comfortable to continue with that position. But when such en masse resignations or retirements do happen, okay, compliance would become difficult. And unfortunately, the law says you cannot do any other business, but in the next board meeting, you have to first appoint an independent director, or it has to be maximum 3 months from the date of vacancy. So it will become a main object of the company to identify independent director. Main objects can be kept aside for the time being. Another point which was made in the audience was whether nominee director is an independent director. If you look at the definition of independent director and thereafter code of conduct, which has been prescribed by a separate schedule, they have specifically said who cannot be an independent director. In that, they have specifically covered nominee director is not independent director. Up till now, many companies who were funded by IDBI, ICICI, and when they used to nominate their person, whether such a person would be termed as independent director or not. Now, yes, to that extent, IDBI, who has given 100 crores and he has been deputed there to safeguard the interest of IDBI, is understandable. But somebody who has given 100 crores to the company, definitely that organization interest is involved. How he can be termed as independent director is a matter of debate. And therefore, under 2013, rightfully, probably they have said nominee. Now, because of this, it has given rise to some other problem. Now, say there is a private company in India or there is a public company in India which is required to comply with this particular provision, which is 100% subsidiary of a Singapore-based company. By investment, a Singapore company will nominate a person on the board of directors of Indian company. So technically in my minutes also, I record in the narration as XYZ's candidature has been nominated by the parent company while resolution passed by that company and so, and therefore it is recommended and resolution be passed. Now with this view of this narration, now can he be termed as nominee director and therefore can he be termed as not an independent director? So therefore, bluntly, he should not be considered as independent director. Now the difficulty is, in last 5 years, at least I have observed a change wherein, though up till now MNCs were having their companies in India, they were having local management in India, but in last 5 years, local management is superseded and the management control is taken back to their parent country. And because board meetings can happen in Singapore, it can happen in Australia, and all that they can control effectively with video conferencing also. Now with this view, if I have to still comply with the provisions of appointment of independent director, naturally from Singapore getting independent director here may not be cost effective also. So ultimately, I have to look out for certain local people who can fit into the bill of independent director. Now, fine, that becomes an exercise. So, whether I like it or not, there is a local management. Whereas, up till now, I never wanted local management. I want total management control to be in Singapore. Now, it is difficult. And secondly, the articles also say that majority of the directors will be as nominated by Singapore parent company. Now, if I have to appoint 3 independent directors here, by no choice in that company, though I don't require, I have to have 4 directors from Singapore. So unnecessarily, I have to have 7 directors on my board, which as such is not required. It has given rise to many compliance issues, practical compliance issues, because now it has been clearly said nominee director is not covered under the definition of independent director. If in case audit committee requires more number of independent directors, then the company must appoint such number of directors. It depends on you having an executive chairman or non-executive chairman and all that. Another category which has come afresh is small shareholders directors, SSDs, section 151. It is applicable to listed companies or wherein there are more than 1,000. Small shareholders or 1/10 of the total number of shares they can nominate. Let me tell you, intention of lawmakers is very good. They want retail shareholders, small shareholders to become more active. But latest annual general meeting which I have attended of the best known companies, small shareholders do not play any concrete role. On a generalized scale, I am saying. If few are doing, probably their motive needs to be checked. Many of them come forward because my photograph should be there on the website of the company. I should be given some kind of attention and felicitation. But the kind lawmakers wanted small shareholders to actively look into the management of the company, whether that purpose will be served. Is it too premature to have such a provision under Companies Act 2013? I have my own apprehensions. Up till now, I have not come across a company where small shareholders representative director is really playing a worthwhile role. But fine, if you are to not be sarcastic and say fine, another 3 years down the line, it could be of benefit from that perspective, you go on complying. SSD will not be liable to retire by rotation. Tenure will be for not more than 3 consecutive years. Expiry, not eligible for reappointment. All these are procedurals, and we can find this. Yeah.
You see in the bank, for the RBI directive,
Yeah.
there will be some directors from the employees. They are neither nominee directors, neither. Now, what is the position? Because Banking Act does not specify like a Companies Act 2013. What will be the position of those directors in compliance?
The question is, first of all, if the question is from a point of view of whether they can be considered as independent directors, is the question directed from that angle?
No, it might be independent directors, might be nominee directors. Because it is coming to the selection from the employees. Board selects, neither the employee goes and vote for it. Board selects that he is a, let me be blunt, because I was associated with some of the banks. Let me be blunt, if he is a union representative, very vocal, okay, make him a director. Now, after this 2013 Act, I don't know what will be their position, whether this Companies Act also applies to the banks or not, because banks are directed by the separate banking 1970 Act.
Number one, it has been clearly settled principle that if you're a company incorporated under Companies Act, be it 2013, be it 1956 or 1914, as the case might be, okay, whatever nature of business that you have, you will have to comply with these provisions. Number one. If you are a listed company, then you have to additionally comply with SEBI and stock exchange bylaws. But you being working as main object in a specific sector called as banking, insurance, and therefore you are exposed to a specific regulator of that particular sector, then every permission, even right from name approval, if you have to take an example, if you go to ROC saying I want XYZ Banking Corporation Limited, ROC says first get license from RBI. So it's a settled principle. If you are a banking company, first obtain recognition of a regulator. If you are an insurance company, first get approval from IRDA and then come to compliance with subsequent regulators and all that. Okay.
As you said, it is listed company. Except the fourth general insurance company and LIC, all banks are listed companies. Because their shares are available in the market. Okay? So now my question is this, whether this 2013 Act, Companies Act, and SEBI regulation section 40, rule 41 or 49, is that applicable?
For an appointment of a director? Question is whether he is a representative of small shareholders, whether he is a representative of employees, compliance with a particular provision for the appointment is anyway required. Say tomorrow, just because he is representing an employee or union, should he be exempted from obtaining a DIN number? No. DIN is required. The moment you have to appoint a person as a director, all compliance under Companies Act, right from DIN, disclosure, MBP1, all such disclosure, filing of DIR 12, all DIR 11, all that is under Companies Act required even for that individual director also.
Okay. Now the insurance companies like New India, Oriental, they are governed by the
Specific law enacted for that particular.
They are registered under the Companies Act. Because section 619(3) CAG gets the power from the Companies Act.
Correct.
Okay. Now in that case, the nominee director, if anybody is there, I don't know what the present position. If anybody is there, he also come under the same.
There has been some circular on this, though the section starts from Companies Act, but the fact that your company, be it LIC, okay, be it GIC, it has come in existence by a separate law called as corporation. LIC has got a separate law.
Yes.
So,
Yes, and separate law, but not for the Oriental, New India, United India, National. They are governed by the Companies Act law, right?
to that extent, they will be governed by. There has been debate or representation white paper made from insurance companies to even MCA, whether to what extent they should be complying with. I happened to attend one such function wherein there was a regional director. He has gone on record in saying that overall at the central government, the approach is rather than creating super regulator, there was a concept, I don't know whether you still remember, they wanted to create a super regulator who will regulate the regulators. That concept has not gone well with. So as of now, if you fall, you're a company under Companies Act, you'll have to comply with the provisions of the Companies Act. Only thing is wherever there's an inconsistency. For example, there's an inconsistency because of which insurance companies are not easily able to come out with listing. So there has been a separate committee set up who will look into, and accordingly Companies Act, SEBI guidelines and stock exchange bylaws will be amended. But till that moment, if Oriental Insurance Company has come into existence because of certain section of the Companies Act, then Companies Act compliance will be required even for that insurance company. Now, in types of directors, I don't know, at such this has not been prescribed anywhere in the section like woman director, SSD or a resident director, but there is definitely a devil involved in the form or name as shadow director. Okay? A shadow director or a de facto director occupying the position of a director without the formal appointment to the board of directors of the company would not fall within the exhaustive definition of section 234 of the Companies Act. The point which I was trying to make earlier definition said who person who occupies the position of a director, and that definition has been changed now, a person who has been appointed on the board. So the concept of a person occupying the position of a director created a de facto control, and therefore he was termed, in the foreign countries it has been termed as he is a shadow director. Okay, so if the intention of the lawmakers is to do away with the concept of shadow director, अगर आपको अपॉइंट किया है तो ही डायरेक्टर हो या नहीं है, आप डायरेक्टर नहीं हो, अगर ये माइंडसेट है lawmakers का, then I think there are some other provisions whereby they have missed out corresponding amendments or the wordings, and one such provision is section 185. If you look at section 185, which still remains the concept of a shadow director when it says any body corporate, board of directors, managing director or a manager who is accustomed to act as in accordance with the directions of. Now if any body corporate, if he is accustomed to act as by Manish, okay, then by virtue of that he will be covered under 185. 185 says loan to directors and etc. That means under 185 he would be still looked upon as a haunted kind of a person, as a director kind of a person, and therefore you have to comply. Whereas the definition doesn't recognize the shadow director, doesn't recognize a person who occupies the position of directors. I think there's an anomaly in section 185. It has to be in line with section 2, definition section 2, subsection 34, whereby in 185 also, it should not be any body corporate who is accustomed to act as. This provision should not have been there in 185, but unfortunately, at one place, the shadow director has been done away with, at the other place, and there could be similar few places where shadow director still has got a technical role and a responsibility when it comes to compliance. General qualifications for independent directors, appropriate skills, experience, knowledge, these are all very subjective. What is appropriate skill, what is knowledge and all that. So every company while appointing will have to take a call. If it's a pharma company, accordingly appropriate skills will be looked into. If it is a shipping company, appropriate skills will be accordingly looked into, and then the company will have to take a call. Every such person needs to have a DIN, consent to act as director. A person cannot be in more than 20 companies and 10 public companies, all that. Yes, important part, some new part in disqualifications. He is unsound mind, understandable. Undischarged insolvent was there earlier also. Now the third one, there is some change in wordings. Convicted by court of any offense whether involving moral turpitude. Now as such, the term moral turpitude then also was not defined under Companies Act. So moral turpitude is a very vague terminology which touches person's integrity, sincerity, character, okay? So all that. CRPC would be very harsh. In any way, then there is no great interpretation required. But imagine, say, in the evening function, after 9:30, under the influence of alcohol, I misbehave. Would you start doubting about my character, integrity, honesty? There's a whole lot of. So what is moral turpitude? There is no definition of moral turpitude. Criminal procedure code would look into whenever I have a guilty mind. No, that per se cannot be taken as a criminal offense in the sense what I had no criminal guilty mind, mens rea. I have no mens rea to cause disrepute to him. It has happened under the influence of alcohol. In fact, the point which is being debated in the latest hit and run case, wherein the lawyer's Audi hit the person and 2 deaths were carried out, culpable homicide case is filed. Question they are trying to debate on is, my intention was not to kill that person. That is the starting. So CRPC will come into primarily picture. No, there could be a criminal offense, but the severity of it will be looked into from mens rea point of view. Whereas here, character, integrity, honesty has probably nothing to do with my criminal record, but still it could speak volumes about my integrity or honesty. So a person otherwise imprisoned for not less than 6 months and 5 years have not elapsed from such sentence. Now this is a new provision. Earlier, they have only said that he has been imprisoned for a period of 6 months or more, he will be disqualified. Now they are saying, fine, he is imprisoned for a period of 6 months is fine, but there should be a cooling period of 5 years. Now, not to again cast doubts on integrity of all big people, but then over a period of time, getting person to be a director itself is going to be a challenge with this such provisions. He has been convicted, this is a new thing which has come, has been convicted of an offence dealing with related party transaction under section 188 at any time during last 5 years. Why I just touched upon related party definition is, you have gone wrong in understanding related party concept. Therefore, you have not termed a person to be under related party. And at some point of time, when something goes wrong, an investigation authority says he is a related party, and being a related party, he has done this particular wrong, and if he has done this particular wrong, per se, he will have to resign. He automatically vacates the position, he becomes disqualified to occupy the position of a director. Such disqualification was not there in earlier 1956. 2013 has a wider coverage, and this new provision, if you have gone wrong in your related party disclosures and if a transaction has taken place, if a case is filed on that, that itself can become a disqualification for you to continue as a director. Then, from a private company point of view, next provision is very important. Absents himself from all meetings of the board of directors in a period of 12 months with or without, why I have put it in red, with or without seeking leave of absence of the board. I recall empty number of private companies, certain directors by rule will be granted leave of absence. And once you grant him leave of absence, the disqualification which was earlier prescribed of 3 consecutive meetings doesn't apply. Now under the 2013, even if you grant him leave of absence and the fact that he has not been attending board meetings for 12 months, itself will become a disqualification. So many of the occasions in private companies, we prepare minutes for 1 full year. Second, we see 2014-15 का कैसे minutes है, cut, copy, paste and change the dates and if possible change the figures for annual accounts. Be very careful, because in cut, copy, paste method, if a person at some point of time has been given leave of absence and if leave of absence, cut, copy, paste goes on in next 1 year, without understanding, the person has been disqualified to continue to be a director for non-compliance, non-filing of return, monetary penalties. The person then continues to be a director, still is disqualified, so individual liabilities. Be very careful who are associated with especially family-owned organization, private companies, granting leave of absence by protocol, by default, practice should be avoided. Stopped. No. Acts in contravention of section 184 or fails to disclose his interest, again failing to disclose interest, then related party are interconnected sections, and 184 and 188 has been convicted of an offense, even if he is appealed against it. Now this is a change. Whether this is right or wrong, it says he has been convicted of an offense, understandable. This was there earlier also. But earlier the provision was, say you have been convicted and you have gone in appeal. Say Salman Khan has gone in appeal. Then till the time that appeal is disposed, you can continue to be a director. That unfortunately 2013 says even if he has been appealed against such order, he will be still disqualified to continue to be a director. Now whether it was warranted, called for, not that I want to encourage such people against whom cases are pending, but I think not always that you have done wrong and therefore a case is decided against you. At times a wrong decision can go against you, and therefore if you make an appeal, I think you should have a right of continue to be a director. That is my personal opinion. I think the lawmakers have gone a step forward. This was not warranted in my individual opinion. Yes, sir.
My individual opinion is as some parliamentarians, MPs have been jailed and disqualified from the membership. They put the same problem.
There has to be a ground of equality and parity. It will open up a totally different debate. I think after Arolkar's first session, this can be continued for, because it's interesting from that perspective. Now, the next important part, again something which we're used to for last 20, 30, 40 years, cannot be done by rule here, it has to be done by exception. If appointed by virtue of he holding office in holding company, subsidiary company, associate company, and if he ceases to hold office in that particular holding company, then he automatically ceases to be a director in this company also. In fact, I know several companies wherein parent company has appointed a director on Indian company, subsidiary. That person has disassociated, gone and joined some other corporates. But he has still continued to be a director on this Indian subsidiary. It has been happening many number of occasions. It has been happening. Okay. Under 2013, be very careful. Now the question that anybody would ask me is, sir, if in Germany, if the person has resigned and joined some other company, how I will come to know what wisdom I do have to ask my parent company, अरे तेरे directors में changes क्या हुआ, तेरा directors का report मुझे दे, so that I can also, what wisdom do I have? How I as a compliance officer will come to know unless they report to me? And just because they don't report to me, I am subject to compliance and a non-compliance, and therefore an action will be taken against me as a compliance officer. I think again, this calls for some discussion, debate, whereby parent company may not inform me. And probably their intention is fine. Now, वो एक company से निकल गया, दूसरे company में गया, he can still continue to be a director. If that is their view, who am I to tell them that no, he is also disqualified from India? But unfortunately, I will have to write a letter in saying he has been disqualified, so resignation or removal. Now, resignation and removal both are acrimonious. It doesn't have a good taste. And therefore, it will call for a lot of difficulties, explanation, special notice, all those procedural aspects that we are used to. Yeah. Resignation of a director, a notice in writing to the company, the board shall, my important word is shall, it is not may or will. The board shall, on receipt of such notice, take note of the same. Now, these words are very important. In 1956, if a person wants to resign, he was at the mercy of the company and the board of directors to accept his resignation. If the board of directors don't accept his resignation, technically he continues to be a director, technically his name continues to appear on MCA website, technically somebody wants to file a case, he takes a ROC search report, finds ABCD to be the directors, और सबके नाम पे show cause notice. And especially when there is a dispute in the families and there is two brothers here and two brothers here. One brother says you cannot, the other brother says, other faction says you can. Me as a poor person, and especially if I am an external person, unless they accept my resignation, I continue to inherit the responsibilities of a director. I think in 1956 that was not appreciated. Under 2013, it is well taken care of. If an individual has informed to the company in writing that he is to resign, one, company shall. That means company doesn't have a liberty of saying no. And second, they have to simply take it on record. Neither a resolution is required. So that can be incorporated in the agenda, and a company secretary can also incorporate this with it, that it has been taken on record. So to that extent, it's a welcome move, and I believe that has done quite a good justice to the fraternity. Director shall also forward a copy of his resignation along with detailed reasons for resignation. Again, I have put it in red. You know what all we were subject or used to? A director is resigning. We only prepare a letter. One-liner letter saying what? Due to preoccupation or due to ill health. Okay? Now, I will again try to connect this with my first starting slide. Say you have prepared a letter for a resignation of a director. Due to preoccupation, I hereby resign with immediate effect. Okay? Second letter, second director, due to ill health. My health doesn't permit me and therefore I resign. बना दिया. ये जाएगा एमसीए में. एमसीए के पास आज के दिन में प्रोफेशनली नहीं साइन किया हुआ फॉर्मेट है विच सेज प्रीऑक्यूपेशन. वही डायरेक्टर 8 दिन के बाद दूसरे कंपनी में जाके एक्सेप्ट्स द अपॉइंटमेंट ऑफ अ डायरेक्टर or take up as an active trustee or some office. Let me tell you, when I have said government is going for over disclosure, they may not misuse it, but they want a documentary evidence in case they want to take an action. Today, with a click, क्योंकि एक दिन नंबर डाला सब जगह पैन बेस्ड ही है तो सब जगह कॉमन आ जाता है. अगर इमीडिएटली दूसरे कंपनी का आ गया कि इधर वो डायरेक्टर अपॉइंट हुआ, इन ऑल पॉसिबिलिटीज एमसीए विल सेंड अ शो कॉज नोटिस दैट व्हेन इन प्री ऑक्यूपेशन यू हैव रिजाइंड ड्यू टू इल हेल्थ यू हैव रिजाइंड ऑन द 8th day you have joined some other company and taken up a trustee of such a welfare trust. Justify, otherwise a cause of action is initiated against you. So be very careful while writing reason why you want to resign. Gone are those days wherein saying preoccupied and all that. Please don't take it lightly. Resignation date shall be effective from the date on which the notice is received by the company, the date specified by the director, whichever is latter. Very logical, nothing greatly to debate upon. In case of all the directors resigned, important one, in case of all the directors resigned or vacate, then promoter shall appoint, or in his absence, central government shall appoint, and they shall hold office till they are appointed in general meeting. Now this is, I would again like to refer to our senior fellow member. If you look at Satyam, when Mr. Raju confessed that I did, and then there was the board of directors resigned, a constitutional crisis led to as to who is going to govern the company, who is going to call shareholders meeting, till that moment company, how they can function. So central government in its own wisdom preferred to appoint 3 people, and if I mistake not, one of them was Mr. Kamath and all that. Okay, they were appointed as Hangami directors, for the time gap arrangement directors. Now this particular decision of the central government was appealed against, the case was filed. From where central government derives powers, it has to be under Companies Act. Central government never had such power except appointment of a central government director, but then it says on the companies where central government controls, not on all such private and public companies. So probably government has learned a lesson, and from there this amendment has come. In an event, majority of the directors resign, thereby it falls below the quorum requirement. Or if all the directors do resign, then in that case, you can go about, promoter can appoint. If not promoter, central government specifically under the law now has got authority to appoint. So to that extent, it is a welcome move. That means in a way, government is anticipating that there could be several companies in line, that of Satyam. Duties of the directors, totally new, something which the directors were unheard of. It was by default, somebody say, oh, you're a director, you're responsible for this, but there was no written down agenda or a mandate that being a director, what is your duty? So I think it's a welcome move. It has been explicitly covered under section 166. Now, some gray areas I would like to touch upon rather than the whole section. Okay, the gray area could be, director shall act in good faith in order to promote objects of the company. ठीक है, समझ लिया, जो कंपनी का डायरेक्टर है उसकी ऑब्जेक्ट के लिए करता है काम. एंड फॉर द बेनिफिट ऑफ स्टेक होल्डर्स, इधर तक भी समझ लिया, इंक्लूडिंग एनवायरमेंट. नाउ व्हाट ऑल ही शुड एंश्योर देन. कल उठ के कोई जनरल मैनेजर, कोई डेप्यूटी सीएफओ, कोई एम्प्लॉई जाके कंपनी का वेस्ट, कंप्यूटर वेस्ट जाके उधर डाल देता है, which is not proper disposal of electronic records. I think director has erred in his duty because it is affecting the environment. I think, to my knowledge, where it is coming from, okay, is in Gujarat, massive action was taken against many companies who were flouting, especially chemical zone companies who were flouting environment norms, water pollution norms, and air pollution norms. At that point of time, when the Pollution Control Board wanted to take an action, okay, they could take action only against occupier, and occupier could be only one director. Whereas other directors were escaping responsibility from the point of view of how to maintain the environment. I think from such provisions, the lawmakers thought that all directors should be made responsible. And how can you make all directors responsible for protection of environment? Prescribed it as a duty. Now tell me practically, you being a director, हर एक कंपनी, और ये इसके पहले वाला ही बोलता है कि you can be a director in 20 companies. पागल हो जाओगे. You need to appoint a department for ensuring all this. How do you ensure that the company is taking adequate steps to protect the environment? Just to quote, nothing wrong, I don't want to create a debate also. आप अगर RCF के साइड से जाओगे, तो क्या, what all kind of air pollution and all that, उसका डायरेक्टर कैसे सोने वाला है रात को नींद शांति से, पता नहीं है मुझे. In a way, understanding board of directors, management, to some extent stakeholders, understandable. Protecting environment has also now become a duty of the individual director because he is being associated as a director in that particular company. Another critical area, he shall exercise his duties with due and reasonable care, skill and diligence, and shall exercise independent judgment. Now, what is reasonable care? What is diligence? What is skill? They are all subject to everybody's definition. Okay, but yes, given the set of circumstances, you can arrive at, in this given circumstances, whether he was prudent in casting a vote or participating in the discussion or not, maybe on circumstance basis. Again, I am saying you have to go behind the letter of law. Letter of law में क्या दिया है? Reasonable care. Letter of law में क्या दिया है? Diligence. Letter of law में क्या दिया है? Skill. But simply diligence, skill, how are you going to interpret unless you understand the scene and go behind the scene in finding out the intentions of the people involved? Therefore, I will again reiterate, simply understanding letter of law is not important. Understanding the circumstances, the processes, and all that will become equally important for we professionals. Should not have conflict of interest even through his relatives, partners, and associates. Definition of related party, disclosure of interest has become so wide. Nowadays, I don't even know who are my relatives, to be honest with you. It would be a very aggressive statement, but that is a fact of life. If I don't even know, अरे, you are my cousin, क्योंकि मिलते भी नहीं है, कभी कभार गलती से WhatsApp पे ग्रुप पे होगे तो hi hello. Otherwise, I don't even know. Now, how should I come to know that my distant cousin, my relative, okay, our associate company is involved, and therefore it becomes my duty that there is a conflict of interest and I go up forward and disclose that interest. It has become extremely difficult. That means government wants all relatives to come closer, meet frequently, and have greater bonding. Otherwise, how are you going to comply with this particular provision? Difficult to comply with. In duties of director, there is something called as knowledge test. It says, if the independent director or a director does not initiate any action upon knowledge of any wrongdoing, such a director would be held liable. Now, upon knowledge of such wrongdoing, how to go about? I will again correlate this with the MIS and board processes. I, at least on this particular account, exactly endorse what the multinational companies follow. छोटी से छोटी चीज मेल पे डालो. कैफेटेरिया में बोला वो चलेगा नहीं, डेस्क पे जाके मेल पे डालो, because then that will become with knowledge. 1. 2. When I have to communicate with him and I keep 4 people in CC, let me tell you, those 4 people don't even bother to read that mail. क्योंकि वो क्या बोलता है, अरे ये तो फाइनेंस का है ना, तो मनीष को किया है, so he will look into, why should I look into? कल उठ के मनीष ने कुछ गलत किया. Investigating authorities will get a trail mail, you were in CC, so it was with your knowledge. Here silence will amount to acceptance, which is contradictory to Contract Act. In Contract Act says your silence doesn't amount to acceptance, whereas here, because you have kept silent, you have kept mum, and you were into that CC, he does something wrong. Can you understand what kind of glaring difficulties in terms of intention of lawmakers while putting it in letters they have made into? Knowledge test would be very critical. So I will again repeat time and again, MIS will become very important. Board attributable processes, documentation will become extremely important. Internal audit will become absolutely important. क्योंकि अगर इंटरनल ऑडिट रिपोर्ट में एक आध इरेगुलरिटी आ गई, दैट रिपोर्ट इज टू बी सबमिटेड टू द ऑडिट कमिटी, इट हैज टू बी गिवन टू द स्टैट्यूटरी ऑडिटर, एंड बेस्ड ऑन विच स्टैट्यूटरी ऑडिटर विल सबमिट अ रिपोर्ट, okay, then nobody thereafter can claim internal audit has done in detail, whereas my audit was sampling based audit, so I was not aware. Internal audit report submit किया था ना, उसमें irregularities italics में दिया था ना, with your knowledge you have done it, and therefore it could be attributable to the duties of a professional. So knowledge test is going to be very important. Even if you are in the CC, it could be with your knowledge, even if you have not acted upon it. So recording of a dissent of a director where an individual director do not agree to the decision must be recorded in the minutes, which can act as a defense. So if you have not agreed to it, mail में भी, if you don't agree, भले आपको फाइनेंस का कुछ समझ में नहीं आता, लेकिन अगर आपको लगता है ये कुछ बराबर नहीं है, 10:1 का लेवरेज रेशो लेके बोरो कर रहा है, अगर आपको लगता है राइटिंग में एक डालो कि आई थिंक आई एम नॉट कंफर्टेबल विद दिस, दैट विल सेव यू रादर देन कीपिंग वन. If the fact that you are in the CC, you could be in trouble with this particular provision. Code of conduct for an independent director, professional conduct. He should uphold the ethical standards of integrity, probity, act objectively, constructively. Good. It sounds good. Feel good is, I don't know. Not abuse his position to the detriment of the company or the shareholder, understandable. Refrain from any action that will lead to loss of his independence. Now, my question is, if independent director's son or daughter takes admission in the school which is run or funded by the company, will I lose my independence? From this point of view. First of all, is it been covered under the definition of independent director? If not, then technically I can be an independent director. Though technically I am an independent director, whether I have lost my independence under code of conduct under schedule 4 because my son or daughter has taken admission. Say for example, I work in Reliance and my son and daughter take admission in Reliance, Dhirubhai Ambani International School. Under code of conduct, under schedule 4, have I lost my independence? Admission to Dhirubhai Ambani school is not open to public scrutiny. It doesn't happen on CET, GATE, whereby there will be a merit list published. There could be internal process. Definitely there is an internal process. But आप और मैं आप गए कि नहीं मुझे ना आपका internal process जानना है based on what you give admission. It will be difficult. So it may not be always merit based. So to that extent, whether I lose my independence to be debated on. It also talks. But that means simply letter of law is not enough. You have to go into investigative role.
Whether you have been called or you like an open advertisement, your son or daughter has applied for.
RTI में कुछ भी हो सकता है बॉस. कुछ भी. हाँ. Role and function under the code of conduct: evaluate objectively performance of the board and the management, satisfy himself on the integrity of financial statements, financial controls, system of risk management. For the moment, you just note this risk management. At some point of time, I will again revisit this. Now, ये तो ठीक था. अभी independent director appoint किया है तो ये सब काम करना पड़ेगा. The last one. Balance the conflicting interest of stakeholders. I don't know why this duty has been cast upon on independent director. अगर मुकेश अंबानी और अनिल अंबानी में dispute है, I as an independent director, what role can I play? And if I have to play, whether I will able to maintain my independence? Extremely difficult. It is impractical. The moment I look into your affairs, stakeholders' affairs, I am going to lose my independence. Because I will have to take a call. I will have to say that you were right, probably you were wrong. The moment I take judgmental, I become judgmental, I think I have lost my independence. And either of them is a stakeholder. How to ensure in the code of conduct that independent director will play a role? Understandable. Mr. Bajaj comes into, Narayan Murthy comes into, they playing a role of a mediator, okay, is understandable. But independent director has been cast a responsibility as a code of conduct to play a role of a mediator was uncalled for, to my individual opinion. Duties are also prescribed: undertake appropriate induction program, update and refresh skills, knowledge and familiarity with the company. Now, to this recent controversy, I want to rake up again in this limited forum. What will be the position in a controversy such as Maggi, Nestle? What would be the responsibility of independent director of Nestle? Would he become disqualified? Keep themselves well informed about the company and the external environment in which it operates. Very, very broad. In this, I would like to again raise a question. What happens when Ranbaxy's US FDA approval is cancelled? What is the duty of independent director? In fact, it was not even properly revealed to a German outfit which took over Ranbaxy. Can you say it was done without a knowledge? There was a US FDA letter which says you have not been qualified now, you cannot continue to manufacture in your Gurgaon, Haryana factory. An independent director says, I am not aware, I am not a pharmacist person, I don't understand US FDA license. He cannot. Even if he is not technically pharmacist qualified person, he will have to understand, go through an induction program. And to me, independent director could also be held responsible for such a controversy that has come into. It's going to be extremely difficult in such situation. Report concerns about unethical behavior. Now, ठीक है. Report concern about unethical behavior. इधर तक ठीक था. आगे. Actual or suspected fraud. Now, how do you go about? आप आपका काम करो. You go after looking at everybody with a yellow eye, he is doing, he is suspecting to create a fraud. How do you come to know? Fine, somebody might argue, sir, there are adequate internal controls, checks and balances, so from that it should come to know. But even from internal controls and checks, to my limited knowledge, it is still a post-mortem. It is not real time. And if it is a post-mortem, something had already happened. How do I come to know suspected? Or kal utke, some opposite faction says you were aware about it. You have not reported this as per your duty. There was enough of scope or room for you to raise a suspect on this. I'm telling you, getting an independent director is going to be extremely difficult job in this duties or code of conduct which have been cast upon. Similarly in NBFCs, whether you are a collective investment scheme company, whether you offer more than or you misuse the LIBOR rate and come out with a product, gold schemes, how a director will protect himself against all such. Now, these are all commercially driven schemes. Let me tell you, gold schemes have been running wonderful. Okay, for many NBFCs, they are doing fantastic business out of it. But all these schemes may not be as clear as they are on the paper. Now, what will be the duty of an independent director? How to? Whether commercial sense should prevail or compliance with law should prevail, and therefore he should put his foot down in saying, though commercially I am going to make a huge business on these gold loans, but legally you should not do it. Let me tell you, no businessman would appreciate this particular view. Commercially fantastic, legally I will not do because it fits into a gray area. Commercial valuation will supersede. They will tell you, you fit it within the framework of law. आपको उसके लिए रखा गया है. कमर्शियली धंधा हो सकता है, करने वाले. ID should at least hold one meeting in a year without the attendance of non-independent directors and members of the management, CEO, CFO and all that, to review the performance of non-independent directors, understandable, assess the quality, quantity and timeliness of MIS. I think with all this duty, other duties are arising out of. If primarily you are supposed to monitor MIS of its timeliness, quality and quantity. Once you are supposed to do this, rest all are supposed to come to know suspected fraud. You're supposed to know through MIS. Probably again, I again appreciate the viewpoint. I think it comes out from, say, if you look at Satyam, 14,000 crore has not happened overnight. It has been made over a period of time. Why employees, with due respect to anybody associated with this, why employees cry foul after they have been chucked out? Because before it was made public, for about 6 to 8 months, their salaries were not paid in time. On one hand, you claim yourself to be a 4th largest IT company, Fortune 500 companies to be your client, and you can't even pay salaries of your employees. That itself should be an alarm bell. Probably out of this, if ID is made responsible for MIS, cash flow, fund flow, those alarm bells should ring. I think the intention of lawmakers that ID should be a superman. Should be a superman. Performance of evaluation of ID is done by the entire board of directors except concerned ID, understandable. You have to stop me wherever you have to stop me because I have a lot of material which I can. Another half an hour, great. That means when he says half an hour, I can snatch. Okay, you only say whenever you feel it's lunchtime and you just cannot concentrate, we'll stop. Board meetings, minimum number of meetings, section 173, first meeting within 30 days of incorporation. It was not prescribed earlier. Now they have prescribed, especially if your client is a private company. Ensure कि जिस दिन में सर्टिफिकेट ऑफ इनकॉर्पोरेशन आ जाता है तभी 8 दिन में ये सब करा दो, अदरवाइज 30 दिन निकल जाएंगे और बैक डेटेड में कुछ हो नहीं पाएगा, डिफिकल्ट हो जाएगा. ठीक है, बिकॉज नाउ अर्लियर ठीक था, 3 महीने प्रोविजन थी. ठीक है, 4 meetings every year. They have not said this time 1 meeting per quarter. Earlier 1956 says 4 meetings in a calendar year and 1 meeting per quarter, January to March, April to June and all that. They have not done 1 meeting per quarter. What they have left with 4 meetings with quarter, I think. Per quarter has been taken away with. Okay? So gap can be 120 days. Gap cannot be more than 120 days between 4 meetings. So the concept of 1 meeting per calendar quarter has been done away with. Notice should not be less than 7 days. If AOA provides for the higher number of days, then the company needs to comply with AOA. Compliance with secretarial standard is also mandatory. For your kind information, especially in small companies, we were not used to complying with secretarial standards. Now it has got a mandatory force. It has been notified. And आज है ना, husband and wife are there. So we take it on a dining table as a board meeting. It may not fit with secretarial standard. And if it doesn't fit with secretarial standard, at the end of the year, जब भी आपको directors report बनाना है ना, उसमें ये reporting आता है. तभी ये नॉन कंप्लायंस करके रिपोर्टिंग आएगा. और ये नॉन कंप्लायंस करके रिपोर्टिंग आएगा तो उसका एक्सप्लेनेशन देना पड़ेगा ऐसे क्यों हुआ. So please be very careful. Secretarial standards could be applicable even to private companies, smaller companies, public companies, listed companies, to everybody, where it says 7 days notice is required. So be very careful while preparing even backdated notices and minutes. Accordingly match it out. Date, time, day as may be convenient to the members of the board needs to be mentioned. Place as may be convenient to the members of the board. I think the same was there in 1956 also. Quorum is 1/3 of the total strength or 2, whichever is higher, including directors who participate by video conferencing. If your articles permit through video conferencing, if your articles don't permit, then you have to still go by the physical quorum. If your articles provide for video conferencing, then that also a person who is participating through video conferencing is also counted for quorum. Now the question is, if a person participates through a mere audio conferencing, can he be counted for quorum? Any call on this? You get my point? There is no video conferencing, there is only audio conferencing. Articles can cover provisions which are there in the law. Law has provided for electronic voting, video conferencing. If you look at the guidelines which are provided for video conferencing, there has to be a clarity, there has to be an audibility. Even if you're visible there, you have to identify yourself that I am XYZ. If you look at all this, I think audio conferencing may not fit into the requirements of video conferencing, and therefore counting him, correct me if I am wrong, Arolka sir, counting him to be for the purpose of quorum would become difficult. Now, ये इतने पे बात खत्म नहीं होती. Problem ऐसा है, a person has participated on audio conferencing. Now the fact that he cannot be counted in quorum, by default, you'll have to grant him leave of absence. Now imagine a situation, he is there for every meeting. He is giving his opinion, he is giving an expert opinion, but technically he has been granted leave of absence. मेरी सब मीटिंग सिंगापुर हो रही है, तो यहाँ का रेसिडेंट डायरेक्टर को साल में एक बार सिंगापुर जाना मैंडेटरी है. अगर वो सिंगापुर नहीं जाएगा, though he is participating in audio call, though the board is taking decision based on whatever he says in the audio call, but the fact that he cannot be accounted for in the quorum, therefore he has to be granted leave of absence, and because he granted leave of absence, he has been absenting himself for 12 months and it will act as a disqualification. Resident director should be happy कि at least by default he should be going once to Singapore or wherever it is. See, it is not that simple whether he should be counted for quorum or not. उसका impact दूसरा भी है, disqualification से भी है. So simply granting leave of absence may not suffice, though you happen to take a decision on audio conferencing and his opinion based. In case of vacancy or interested director not participating, thereby leaving the remaining number of directors below the quorum requirement, then remaining directors act to increase the total number or for convening the general meeting. I think the same provision was there in 1956 also. It was known as deadlock in the management. If it is a deadlock in the management, you have to increase the number of directors or you have to convene the shareholders meeting. In case of interested directors exceeds or is equal to 2/3 of the total strength, remaining number so far as not less than 2 constitutes a valid quorum. Now, to me, this is a minor deviation from Companies Act. Because इसका मतलब ये है कि अगर 2/3 directors are interested, remaining 1/3, say my quorum requirement otherwise is 3 or quorum requirement was otherwise 4, as per the other provisions of the Companies Act, quorum for a board meeting, 1/3 of the total strength of the board, whichever is higher. तो उसके हिसाब से समझो मुझे 4 directors होने जरूरी है quorum requirement के लिए. ये केस में because more than 2/3 directors are interested, thereby remaining number is less than 4. But even if it is 3 or 2, law says it is adequate quorum. Now, I think it is defeating the purpose of calling a quorum. If at some point of time, which is a primary mother section, saying quorum, there is a secretarial standard for this about quorum requirement. And as per that, if it says 1/3 or a 2, whichever is higher, as per that in my company, considering the total strength, I require 4 directors to be there for quorum. Now, just because 2/3 are interested, now it should have been otherwise. Majority of the directors are interested. How only 2 directors, when my quorum requirement is 4, should take a decision? पहले क्या था 1/3 और 2, इफ उसके लिए इलेबरेट प्रोसेस था कि इंटरेस्टेड डायरेक्टर्स इज 2 और लेस, इवन इफ इट इज 1, देन यू कैन गो टू शेयर होल्डर्स और गो टू द कंपनी लॉ बोर्ड. अभी तो ऐसा कुछ है ही नहीं. कंपनी लॉ ट्राइब्यूनल तो अभी आ रहा है. सो टू मी व्हेन दे सेड दैट 2/3 so far as it is not less than 2, I think they should have said 2/3 so far as it is not less than the quorum requirement constitutes a valid quorum. But they have said it too, and it will have its own repercussions. Next, it says board meeting cannot be held for want of quorum, then unless AOA provides otherwise, it shall stand automatically adjourned to the same day, time, place in the next week. I don't know, ये provision draft करते हुए concerned आदमी कहाँ बैठे थे. I think they have copied it from shareholders meeting. If you recall, if for want of quorum, shareholders meeting has to be adjourned, then it gets automatically adjourned on the same day, same time, same place in the next week. How can you apply it to the board of directors? Suppose this was the boardroom for today's board meeting, and for some reason, excessive rains or some calamity, if the directors cannot come, there is no quorum and it gets adjourned. How can I take for granted that park will give me same room next week, same time, same place for me? How can I, in all the possibilities, it will not be available. There was no necessity of saying this. It should have been left to the board of directors to decide what will be the next meeting. ठीक है, ये क्या कम था? उसके आगे. If that day is a national holiday, then next succeeding day, which is not a national holiday, will be the board meeting. Now, this is again a deviation from Companies Act 1956. Companies Act 1956 में first of all national holiday का concept ही नहीं था. Board meeting could be held on any day, which is convenient to the members. It can be Sunday, Sunday, 15th August, 15th August, 2nd October, 2nd October. What's wrong? Here now they are specifically saying, even that too for automatic adjournment, that it happens to be a national holiday, then it becomes the next day. That means per se, like shareholders meeting cannot be held on a national holiday, even the board of directors meeting cannot be held on a national holiday. This is ridiculous. If the parliament can approve a particular bill, as Samandra sir has said, at 10:30 in the night, I think it should be left to board of directors to decide when to meet, when to carry out a business, why they should be very skeptical about you not working on 2nd October, 15th August, 26th January. I think unwarranted, but it has crept into. Minutes of the board meeting, draft to be circulated, yes. Those who have been writing minutes for especially small companies and private companies, be very careful. It says draft to be circulated, physical or through electronic mode, within 15 days of conclusion of the meeting. And the good practice in the good corporates is within 7 days. If you want to prepare backdated minutes, karwa diya. How will you legally prove that it was circulated within 15 days? करके बताओ. That means एक wrong करने के लिए आपको और 4-5 खून करने पड़ेंगे. And once you do one wrong, imagine करो जिस दिन नोटिस दी बताई है, ओके, उस दिन ऑफिस बंद था. नेवर नो. उस टाइम डायरेक्टर्स या कोई कंट्री में ही नहीं थे. क्या करोगे? What is effective serving? And many companies are not used to electronic mode कि भले छुट्टी है, वो यूएस को गया है, मैंने मेल भिजवा दिया, मुझे डिलीवरी रिपोर्ट भी आ गया, तो लीगली आई एम ओके कि डिलीवरी रिपोर्ट आ गया. When in a conventional matter you send physically, director is not there. जून में सब लोग बड़े आदमी लोग यूएस जाते ही है. बैकडेट में करो अभी. To me, especially for private and small companies, while preparing minutes, these aspects should be taken care. Any director wish to suggest changes and comments, dissent, must, mind the word must, communicate within 7 days of receipt. If you keep mum on my draft, which as a company secretary I have circulated to you, you kept mum, it will amount to acceptance against contractual provision. And then it will be with your knowledge. And once it becomes with your knowledge, it can be termed as willful. Imagine karo kya kya ho sakta hai. Okay? So if you don't agree, that means lawmakers have expected you as a director to read. And if yes, say yes. If no, say why no. Give comments. That means one director reading and the rest of the directors act as a dummy directors is not what is envisaged under 2013. You will have to educate the directors कि मेल लिखो मुझे कि I am okay. Orally बोल देंगे चलेगा नहीं. So you need to bring about a cultural change in your company where you consult. Okay, you have to tell the director that send a message to me within 7 days. Minutes to be signed within 30 days of the conclusion of the meeting. Now here there is a technical issue. Even secretarial standard says minutes to be entered in the minutes book and within 30 days. That is what secretarial standard says. Here it says minutes to be signed within 30 days. Question is, say I have circulated minutes within 15 days, sorry. Directors have responded me with their comments within 7 days. But thereafter, chairman has gone abroad, he is not available, and the minutes cannot be signed. And because minutes cannot be signed, therefore, I cannot enter in the minutes record within 30 days. And therefore, there is some non-compliance with the provisions of 118. How would you tackle this situation? Are you getting my question? I have circulated minutes within 15 days. All directors have commented to me within 7 days. Everything is over. सबका comment tabulate करके मैंने final draft बनाया. लेकिन chairman is traveling and somehow he is not reachable. He is on vacation. जो भी है वो. And the fact, bottom line is, it cannot be signed within 30 days.